Parking stations seem to produce wonderful contract law cases. Mr. West turned up at a parking station operated by the Sydney City Council. He drove in as part of the stream of traffic. The parking attendant handed him a ticket and told him to follow the other cars. He had no opportunity to read the ticket, but if he had, he'd have read, "The Council does not accept any responsibility for the loss or damage to any vehicle or for loss or damage to any article or thing in or upon any vehicle or for any injury to any person, however such loss, damage or injury may arise or be caused." Mr. West parked his car and left. Later on, a fellow calling himself Robinson turned up and said that he had lost his ticket. They issued him with a replacement ticket and he got into Mr. West's car and drove away, giving the ticket to the attendant on the way out. Mr. West sued for the loss of his car and the council sought to rely on the exclusion clause. I think it's fair to say that courts don't like enforcing exclusion clauses where that seems to produce injustice. In this case, the court applied what is now known as the Four Corners Rule, that the only conduct which can be protected by the exclusion clause is conduct which occurs within the four corners of the contract. Chief Justice Barwick and Justice Taylor said, "To our minds, the clause clearly appears as one which contemplates that, in the performance of the Council's obligations under the contract of bailment, some loss or damage may be caused by reason of its servant's negligence. But it does not contemplate or provide an excuse for negligence on the part of the Council's servants in doing something which it is neither authorised nor permitted to do by the terms of the contract." In other words, if Robinson had simply sneaked in and stolen the car, driving it out when the booth was unattended, there would have been no liability. But the car park delivered the car to him by giving him a ticket and raising the boom gate. That conduct was entirely outside the four corners of the contract, and so it was not protected by the exclusion clause. Exclusions will only exclude liability for conduct within the four corners of the contract.